So friends, in a new court filing, Special Counsel Jack Smith goes hard after a gag order for Donald Trump, trying to get him to stop endangering witnesses and poisoning jury pools. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So friends, Special Counsel Jack Smith just filed a brief in court pushing back on Donald Trump's claim that the judge can't limit his speech, can't limit it in any way. Of course, Donald Trump is wrong about that. His lawyers are wrong about that. They are objectively wrong based on the law. And I predict when a hearing is held on this issue, and that hearing is now scheduled for October 16th, I will attend that court hearing. When a hearing is held on this issue, Judge Tanya Chutkan will impose limits on Donald Trump's speech and on Donald Trump's posts to prevent him from continuing to endanger the witnesses and from continuing to try to poison all future jury pools. But what I want to do today, friends, is I want to go through just a few passages of the prosecution's brief to try to highlight how Jack Smith and his team of federal prosecutors really are going hard after justice. Now, I know it's frustrating. I know it's taken too damn long. Yeah, and yes, we continue to see Donald Trump endanger witnesses and poison jury pools day after day after day. But Jack Smith really is fighting hard for we the people and our right to a fair trial. So let's look at some examples in this recent court filing about why I say Jack Smith and his team of federal prosecutors are fighting hard for justice. There's the newly filed brief, United States of America versus Donald J. Trump, defendant, and it's captioned, Government's reply in support of opposed motion to ensure that extrajudicial, meaning out of court, statements do not prejudice these proceedings. After the defendant and his counsel engaged in weeks of widespread public statements threatening the orderly administration of justice in this case, the government filed a motion seeking a narrowly tailored order placing restrictions on all parties' extrajudicial statements, which carefully balances the defendant's free speech right with the court's responsibility to ensure a fair trial free from outside influence. In the defendant's opposition, premised on inapplicable case law and false claims. Let me pause there, friends, because that is an unvarnished account of what Donald Trump and his lawyers are doing. I have seen many briefs that were filed where the language was very circumspect and genteel. That is not how Jack Smith and his team are litigating this case. Let's go back to the brief. In the defendant's opposition, premised on inapplicable case law and false claims, he demands special treatment, asserting that because he's a political candidate, he should have free rein to publicly intimidate witnesses and malign the court, the citizens of this district, the District of Columbia, and prosecutors. But in this case, Donald Trump is a criminal defendant like any other. And as this court has correctly stated, it has an obligation to protect the integrity of these proceedings from prejudicial interference. And then they quote Judge Chutkan herself, quote, in a criminal case such as this one, a defendant's free speech is subject to the release conditions imposed at arraignment and must also yield to the orderly administration of justice. The defendant should not be permitted to continue to try this case in the court of public opinion rather than in the court of law, and thereby undermine the fairness and integrity of this proceeding. The government's motion should be granted. Jack Smith then highlights exactly who it is who created the circumstances that necessitate this request for a gag order, for a restriction on Donald Trump's speech. The proposed order is necessary under the circumstances that the defendant himself has created by waging a sustained campaign of prejudicial public statements regarding witnesses, the court, the District of Columbia, and prosecutors. Then Smith goes on to highlight how Donald Trump has been trying to use his political candidacy as cover. Trump has been using, quote, his candidacy as cover for making prejudicial statements about this case. And there is no legitimate need for the defendant in the course of his campaign to attack the known witnesses regarding the substance of their anticipated testimony or otherwise engage in materially prejudicial commentary in violation of this proposed order. And then, friends, Jack Smith reproduces in this court filing Trump's post in its entirety, suggesting that a witness against him, General Mark Milley, should be executed. And here is what he goes on to say about that. No other criminal defendant would be permitted to issue public statements insinuating that a known witness in his case should be executed. This defendant, Donald Trump, should not be permitted either. And friends, let me just pause here for a moment because I feel the need to go one step further in the analysis. Any other defendant who is on pretrial release in a federal felony case, indeed Donald Trump is on release in 4 felony cases, any other defendant who advocated for the execution of a witness against him would immediately be revoked on pretrial release and detained pending trial. And yes, I know I said that Jack Smith and his team of federal prosecutors are going hard after justice and are representing we the people extraordinarily well. I believe that. I will stick with that. But Donald Trump, and I've said it before, given the extreme threat he poses to witnesses, should be revoked on pretrial release and should be detained pending trial. But the good news is I think that is precisely where Donald Trump will end up, because the judge will impose a gag order, will impose some limitations, some restrictions on Donald Trump's speech and on his posts, and Donald Trump will inevitably and probably immediately violate those restrictions. And I do believe he will ultimately see the inside of a jail cell pending trial before he is ever convicted at trial. Here is how Jack Smith wraps things up. In sum, the government has provided the court with a robust factual record to establish that the defendant's pervasive public comments about this case, the witnesses, the court, and prosecutors present a substantial likelihood of material prejudice to these proceedings. To prevent that prejudice, the government has proposed a narrowly tailored order placing limited restrictions on the public statements of all parties to this case. In response, the defendant's opposition demands special treatment, asserting that the defendant's desire to publicly malign witnesses without restriction prevails over all other interests, including that of the public in the fair administration of justice. The court should treat this defendant like all others and enter the government's proposed order. So friends, Jack Smith and his team of prosecutors are fighting for it. They are fighting for accountability. They are fighting for justice. And yes, it is a long treacherous road, but we will keep traveling it together. And in time, I absolutely believe, we will arrive at a better place, a more just place. Because justice matters. Friends, as always, please stay safe, please stay tuned, and I look forward to talking with you all again tomorrow.